If you're watching this video, you may have recently hired a lawyer, or you may be considering hiring a lawyer. In this 5-part video series, we'll take a look at everything that you need to know to save money and get the most out of hiring a lawyer. At the end, I'll tell you how you can download my template for getting all of your information together in one place so that you can give your lawyer everything that they need to do a great job for you. Keep watching. Before I begin, please keep in mind that I'm not giving any legal advice in this video and that watching it does not create a lawyer-client relationship. If you think that you'd like to ask a question that's specific to you and your situation, please comment below and I'll do my best to respond promptly. Rule number 4, be reasonable. Reasonableness is a standard commonly used by lawyers, judges, and other decision makers. Over the past few decades or so, many high-profile cases which have been in the media have caused some people to wrongly think that the law routinely delivers unrealistic results. For example, many people think of the famous case involving a person who was burned by a hot beverage from a fast food chain and believe that the case means that they can get millions of dollars for a similar injury. In most cases, it doesn't work this way. Legal remedies and restitution laws vary from jurisdiction to jurisdiction. But in general, the goal of the law is to put a person in the position that they were in before the damage occurred, as much as can be done with money. For example, if someone were to rear-end you in your car, cause you to break your arm, and miss a month of work, it may be reasonable to expect to be compensated for the cost to repair your car, the wages you missed from not working, and the pain and suffering that you've endured. You may even be able to get punitive damages if the person was driving negligently or recklessly. However, generally speaking, in the world of motor vehicle collisions, a broken arm is a relatively minor injury. And if you think that you're going to get millions of dollars, you may need to think again. If you're not sure what is and is not reasonable in any given situation, that's understandable. And your lawyer can help you understand where the goalposts are and what outcomes are and are not likely. However, even before speaking with a lawyer, temper your expectations and set reasonable ones so that you won't be disappointed or surprised if it seems that you can't get as much money as you were hoping for. Along with steering clear of unreasonable expectations, you should also avoid insisting on answers to questions that may be unreasonable depending on the circumstances. For example, if you're having a consultation with a lawyer to explore whether you may have a legal claim and have grounds to start a lawsuit, it may be unreasonable to ask how long it would take to complete the work, if an all-in cost can be provided at the start, if the lawyer can do the work for less than someone else, if the lawyer will do the work for less than their usual rate, if success can be guaranteed, and what the likely result will be. For many of these questions, the lawyer may respond with the rhetorical question, how long is a piece of string? Which means in essence that the question can't be answered because there are too many variables and too much uncertainty. Even for seemingly simple cases, it's often impossible to estimate how long a lawsuit will take, how much it will cost, and what the result will be. Further, success can never be guaranteed, and it's in poor taste to ask a lawyer if they'll price match a competitor or work for less than their typical rate. On the subject of legal fees, you should also be reasonable in your expectation of what your lawyer will be charging you and when you'll be receiving bills. This is information that you should be getting directly from your lawyer. No matter what kind of work your lawyer is helping you with, you should always insist that you be provided with a retainer agreement which lays out important information such as what work will be included, what work will not be included, how much the work may cost all in, if it can be reasonably estimated, when you will receive bills, whether you need to provide a retainer, and if so, how much, what you will be responsible for doing, and what the process may look like in general. Although retainer agreements may be drafted in a way that protects the lawyer's interests, it should also contain many provisions that are designed to protect and inform you as well. If you receive a retainer agreement from your lawyer but you don't fully understand it, or you'd like a second opinion, you can always contact a lawyer such as myself to help you understand it and provide an impartial second opinion. In general, you should expect to pay a reasonable retainer. In my career, I've encountered many people who have either refused to pay a retainer or have said that they'd be happy to provide one, but never did. In general, lawyers are good at detecting people who are trying to get something for free, and these relationships usually don't last long. As much as possible, you should pay your bills promptly and avoid being difficult about them unless you think that there's something wrong with the charges. If need be, you can take it up with your lawyer directly, or you may wish to get a second opinion from another lawyer and avoid potentially souring the relationship. If you have any concerns, your best option may be to get a second opinion from a lawyer like me on whether everything seems to be on the up and up. Assuming that everything's fine, I recommend that you do the following. Follow reasonable advice and give reasonable instructions. Depending on the kind of work your lawyer is doing for you, they may at times present you with different options and opinions on what you should do. Returning to the example of the rear-end collision that I used earlier, if the defendant offers your lawyer $100,000 to settle the claim, your lawyer may suggest to you that you take one of the following actions. A. Accept the offer. B. Reject the offer and make a counteroffer. C. Reject the offer and make no counteroffer. D. Do nothing and let the offer expire. If we were to assume that your arm healed quickly, that you missed only a week of work, and that it cost only a few $1,000s to fix your car, an offer of $100,000 may be quite favorable, and your lawyer may explain to you why you should accept the offer and how it may be a good amount of compensation that is safer than if you were to proceed to court. If you were to instead tell your lawyer that you want to go with option B and make a counteroffer just because you thought that you could get a few thousand more dollars, your lawyer may disagree and warn you that making a counteroffer could risk losing the initial offer. In this situation, it may be unreasonable to not follow the lawyer's advice and fail to go with option A. Although there's no single definition of what it means to be reasonable, you should always be striving for the standard to get the most out of working with a lawyer. So there you have it. If you learned something new from this video, then make sure to subscribe to my channel right now. Just click the subscribe button below this video. And now I'd like to turn it over to you. How important do you think the tip in this video is to getting the most out of hiring a lawyer? Let me know by leaving a comment below right now. To download my template for getting all of your information together in one place, please visit my website, www.seandoman.com. Thanks again for watching. I'm Sean Dillman.